And there's been mixed reaction to the Pretoria High Court's landmark decision declaring some sections of the Sexual Offences Act unconstitutional. It means that rape suspects can no longer use the subjective belief of the complainant's consent as a defence for the crime. The Justice Department's advocate, Peace Kambula, is with us now for reaction to this judgment. Advocate Kambula, good evening to you and thank you for your time. Let's begin with the reaction of your department to this verdict. Do you welcome it?
Good evening, Polly, and good evening to the viewers. All right, let me start just by saying that we are not entirely objecting to this judgment. We are, what we are not opposing first is that we are aware that there is a scourge of rape in our country. We are also aware of the fact that, which is something that we are not opposing as well, is that we have rape is a violation of a constitutional right, that we have a mandate as a department to ensure that we protect the rights of the victims of rape. We are also not opposing that it is a crime that predominantly targets women and children and the gender non-conforming persons as well, who are the most vulnerable in our country.
Yeah.
One thing that we were opposing was the scraping off of the element of consent from the definition of rape. If you check from our legislation, Section 3, the definition of rape. Rape is the unlawful, intentional commission of an act of sexual penetration without a consent. So it means that there are 4 elements that the prosecution must prove beyond reasonable doubt. And if you take out then consent, what it means is you are silencing the voice of the victim. And that is what we were totally against of, because we wanted to have a criminal justice system and the proceedings that are victim-centric, where the voice of the victim is heard. In every sexual engagement, the one who wants to have sex with you has to ask for a permission, all right? And the lack of consent is a lack of intention, all right? It's a lack of lawfulness. So that is basically what we were opposing.
So just explain that a little bit more when you say that the element of consent, which is what the ruling has now effectively amended, when you say that it silences the victim's word, how do you mean, or what do you mean by that when you say the victim is effectively being silenced?
If we scrape off the element of consent, all right, what we are saying is that the person that you want to engage in a sexual act with cannot give consent, cannot say that, okay, we can do it, all right? Because as you know that the act defines the consent as it must be a voluntary or a non-coercive agreement, all right? So if now we take out consent, we are making the perpetrators to have their way without asking. Because consent means that there must be that agreement which must be voluntary. And the same act also indicates circumstances where the consent is eliminated. That is, where there is a submission because of fear, a submission because of intimidation, all right? Or maybe there's an exercise of power and control. So in those circumstances, all right, there is no consent. So we want the voice of the victim to be there. But anyway, the judge concurred with us in that aspect. Now, when we come to, because now you'll be talking about the subjective belief test, all right? It's a pity that this judgment did not consider the Supreme Court the Supreme Court appeal division or a judgment of the Toko the Toko judgment. We have a Supreme Court appeal a judgment of Togo, which actually dealt with the same situation. It was dealing with the elements of the crime of rape, and it looked at all these situations and also indicated that, you know, in our law, we should not be having a subjective belief test in cases when the court is determined to be the presence of the consent, all right? So, but it is one a decision that this court did not take into account. So now we are sitting with a Supreme Court appeal judgment that considered the elements of a crime of rape, and in its consideration, which was, of course, a full bench judgment, in its consideration, did not see any unconstitutionality in all the elements of rape, including consent. So that's where then the challenge is, you know, with us. But as a department, we are studying the judgment, and we have also requested the NPA to give us their input. We are at that stage. So for us, it is a judgment that is a bit controversial, all right? But we do agree with the judgment in certain areas. But we cannot right now say that we are fully in agreement with it. As I said, that we are studying the judgment.
Okay. So you may possibly challenge it at a later stage. We don't know. As things stand, this will then have to go to the Constitutional Court, and you'll correct me if I'm wrong here, based on my understanding, for ratification. But that assumes that the department leaves things as they are. I just want to ask you one quick question before we wrap. What implications does this have for the perpetrator?
You know, the perpetrator, if you look at this judgment, all right, and you look at the subjective, because it is also scraping off the subjective belief test, all right, to an objective test. So all the elements that are there that the prosecution needs to prove are still there. So there is absolutely no change in terms of the seriousness of the offense, all right? That is also in terms of now the defense by the accused person. There's absolutely no change in that area. So meaning that we will still have prosecution that will be, we don't see any prosecution that will be like you are increasing the burden of proof on the prosecution. Because let me tell you, Flori, that if a victim says a no, all right, the communication of that no is communicated differently, all right? Because some of the victims will be saying that, you know, if I say that I am tired right now, that's a communication of no, all right? So it does not have to be expressly no.
Yeah.
So the behavior of the complainant also, all right, indicates it's a communication of a no. It's a communication of the lack of consent, that I'm actually not consenting in this issue. And that is what the prosecution, that's the evidence that the prosecution will be leading. So the complainant is actually not silent in this aspect, all right? So we don't see any change in terms of acquittals. There's not going to be any acquittals in terms of this judgment. We don't see any acquittals.
So but it does place the burden of proof on the alleged perpetrator. Am I correct?
Yes, it does.
Okay. All right. Thank you very much for your time, Advocate Kambula.